and welcome to Domain 6, talking about third-party risk management as the last domain, the last section of information and details as you get ready to sit for your HCISPP exam. The definition of third parties in healthcare are those individuals who are hired outside of the primary entity to provide a specific function or group of functions in support of the primary entity. As we look at health information use, and you certainly should be familiar with what that means with regard to HIPAA's privacy rule as well as the security rule. When we look at third-party management vendors, we are looking to connect each particular type of vendor with the information that they will provide, they will secure, they will process for us, the primary entity. And depending upon what specific information they are going to be working with and what the specific function is, will help determine what type of risk potential they are to our patients. And remember that even if we can transfer the risk, we still have an ethical responsibility to our patients. We are the ones collecting the data, and just because we pawn it off or send it off to a third party does not mean we are totally relieved of all responsibility, whether it's ethical responsibility or legal responsibility. So as you are evaluating the vendors and determining what exactly they will provide, you want to make certain that you're doing an analysis of exactly how the information they're dealing with, how protected is it, how sensitive is it, when they will have access, how they will have access, the frequency with which they'll have access, and of course the methodology. This is all very important, and remember, it is our responsibility to ensure that business associates are well educated in HIPAA's privacy rule, and when they are technological vendors, the security rule as well. So the third party role in relationship to the primary entity, and remember the primary entity is us, our hospital, our clinic, our facility. The relationship between this primary entity, our hospital, and the vendor can help identify potential risks. And again, remember that once whether you as the manager of the department or whether it's an administrative decision or even a board of governors decision for the facility, once a decision is made that this particular function, this service, this job responsibility is going to be outsourced, then the I's need to be dotted and the T's need to be crossed with regard to specific pieces of data, specific responsibilities with regard to that data, and you need to, as you look for the right vendor, look to someone with whom you can build a relationship, because that has been shown to improve productivity as well as the compliance issues, because the relationship can forge a desire to protect each other. And with that comes that security, the security concepts and the details, especially those with which we need to comply. So this now brings us beyond hiring an outsourced company to do coding or billing or whatever it might be. we now have to move into another part of leadership and management, and that's relationship management. And every relationship, seriously, every relationship begins with clear expectations. This has to do with the relationship between a manager and his or her staff, between a facility and his or her staff, between the primary entity and the vendor. And this must be a detailed accounting with regard to expectations, policies, and procedures that are not only written to protect both entities, but to make sure that communications is clear. There are no assumptions, because assumptions are the gray area of compliance, and that's where all the trouble happens. Okay? So, after the RFP process, the request for proposal, and the determination process of which vendor you are going to engage, there is an 11-step process here in this relationship management, and it goes on to the next slide. We'll get there in a second. To discuss your responsibilities to engaging and supervising this vendor. This is never a hire this vendor, great, I have nothing more to do with billing, so I don't have to worry about it. Sorry, no. Okay. You must sit down clearly. You must sit down with the vendor and go over every expectation individually and confirm that they understand, and also make certain that the contract is very clear. All right, so as you go through, you see the first 6 here starts with what I was just saying, the expectations, and the fact that the vendor must comply. And again, I have seen agreements where it says the vendor must comply with all applicable federal and state laws. Well, I'm sorry, ladies and gentlemen, that just doesn't cut it. You have to be very specific with what laws they have to comply with and how to comply, or provide training, or whatever is necessary. That includes being very specific with the security and privacy safeguards. You cannot, should not ever assume knowledge. You need to make sure that you are contractually maintaining the right to audit this vendor at any point. Now, generally speaking, the audits are built into the contract to be on a regular basis, like quarterly or semi-annually. But make certain there is a clause in there that says you have the right to audit after a breach, after any kind of incident or event, as well as just because. Surprise audits are very clear in what they show us, and are as important as anything else to making certain that everything is being done properly. And the buck stops with you, not with them. Again, you need to clearly identify the notification protocols in the event of a data breach or a suspected data breach. Again, do not assume knowledge. This must be carefully and completely spelled out. And the location of data access, storage, and processes. You have to know where your stuff is that you're giving them. And you might say, well, it's all in cyberspace. It's in the cloud. Well, you know what? The cloud is really not in the sky. I'm sure most of you know that. The cloud is just a term for a server in a server farm somewhere. Okay? You need to know where that is. Okay, and we continue the last 5 parts of the data of the relationship management features that you as the manager must make certain you are complying with and engaging in the contract and the agreement with the third-party vendor. Data return or destruction at contract termination. And Again, this needs to be complete. All data in all forms. Don't just say on CD or email or whatever. You need to state all forms. And destruction, if you are going to permit them to destroy any of the data belonging to your entity, you need to make sure that they understand the regulations with regard to how to destroy, and make sure there is a certification, notarized statement of the destruction and how it occurred. Employee background checks and employee verification. You know, their employees are touching your stuff. So therefore, you need to make sure that their staff is vetted. Expectations for employee training. This needs to be specified. We expect you to train all of your staff in HIPAA, privacy, HIPAA, security, whatever. The ability of the vendor to subcontract work. Will you permit them to take it a step further and send it to, what, I guess that would be a fourth party vendor? You know, somebody else. This has to be discussed. This has to be agreed upon and very specific. Because remember, you are going through all of this to make sure that you are valid in feeling confident to entrust this other company with your most precious product, which is patient health information. Can you trust them to properly vet someone else because you are still on the line for this? And then you must make sure that they have business continuity and disaster recovery plans, because their tornado may not affect you. However, if they don't have a business continuity or a disaster recovery plan, you and your patients are still affected. And you can't just let that happen. You can't let someone else's business practices rule your business practices, especially when it comes to healthcare. All right. In addition, there must be organizational standards set forth. Who, how, will technical testing be included? Who is going to perform an assessment or audit? How often will it be performed? How much notice will the vendor get before the audit? And I suggest you make that anywhere from 0 minutes to 30 days. And will technical testing be included? Well, it would be my suggestion, because if technology is involved, then you have to make sure the technology is working properly. Okay, triggers of third-party assessments. We touched upon this a little before, but again, you need to have a contractual requirement for an audit. Like I said before, whether it's quarterly, semi-annually, whatever that might be. A non-standard assessment post-breach. Okay, this is absolute, because even if the breach has already occurred, there's nothing you can do about that, except you need to get over there and assess their recovery after the breach. So what are they going to do to make sure this doesn't happen again? That is your responsibility. And the contract should, of course, state that the vendor will be financially liable for the post-breach audit and any remediation and notifications, because this can be quite costly. And you know what? It doesn't even matter if it's $1. If it's their mess up, if it's their fault, then they should pay. And remember that sometimes it's the financial ramifications of bad behavior or lackadaisical compliance that gets their attention. Information asset protection controls. This goes back to something we have been discussing throughout almost all of the domains, which is, remember that this is one of our top jobs, is protecting our information assets, and that's every character, every number, every letter, every piece of data, whether it's clinical data, financial data, it doesn't matter. And all of this information has a street value. And as we discussed, I think it was in the beginning of Domain 4 or maybe Domain 5, we talked about the street value and the comparison between the street value for a Social Security number that's been stolen, which is about $1, compared with the street value for medical identity information, which has a street value of $50. That is a very strong temptation for criminals. And remember that, yes, I call this the 80-10-10 rule, okay? 10% of the people are just criminals at heart. They have no ethics. They have no... They are very people, okay? And if it benefits them, that's all they care about. And they'll do anything they can for their own benefit with absolutely no concern for anybody else's harm or discomfort. You have 10% of the population that are good, honest people, and honestly, virtually nothing is going to make them break the law. Whether it's a legal issue, whether it's an ethical issue, these are stand-up people who cannot be cajoled. And then you have that 80% in the middle, okay? You can have good, honest people who on a daily basis would never think of stealing medical identities and selling them until that day they get the notice that their house is about to be foreclosed, or their mother needs a heart transplant, or whatever it is that pushes them against the wall. When people are between a rock and a hard place, their priorities can change. In addition, you have people who, whether intentionally or accidentally, can fall into substance abuse, develop mental or behavioral disorders, and whether that's the staff making the temptation to steal more acceptable in their own heads and their own hearts, then you also have the patient information that is super confidential, which requires more protection. So that is a two-sided blade with regard to protection controls that must be in place. When you are looking at compliance with these controls, you must remember that you have the guidance you need from all around you. Most of it will come from HIPAA and high-tech. And remember that third-party vendors, even though they may not be covered entities, are still business associates, which means they still have to comply. And it's your responsibility to make sure that they know this, that this is in the contract, and that you can hold them accountable. The language must be included in the contract. And this is really easy because it's on the Department of Health and Human Services Office of Civil Rights. In the HIPAA portion of their website, they have everything you need, even the legal language already written that should be inserted or must be inserted into a business associate contract. So it doesn't matter if you're a little clinic or a one physician office and you don't have the funds to go hire an attorney to do this specifically. The government is providing you with the information. All you have to do is copy and paste. And unlike our classroom, that's okay. All right. And compliance activities, these are an absolute must. You have to teach people how to be compliant and then let them know that they will be expected to comply. So communications with the vendors are very important, and generally speaking, this also should be documented, because if it is not specifically spelled out, I have seen contracts where it'll say the third-party vendor must notify the primary entity as soon as possible after a breach. Well, how long is as soon as possible? How are you going to get them to comply to that? Then they're going to say 60 days later, well, this was the soonest we could get to it. We were busy doing other stuff. Okay? And then you have to say, well, that's not acceptable because now the federal government's going to come down on us. So you must be communicative in writing explicitly, and also provide them with the findings after a risk assessment so that they know what they have to do, what they have to fix, what has to be corrected. And then you, again, must follow up to make sure that those corrections were completed. I'm sorry to tell you this, but you can't just take people's word for it. You just can't. And the fact is, and I'm going to remind you this as often as necessary, is your neck is on the line here. So if you want to put your future career and possibly fines and penalties and possibly jail or prison time, and you want to trust some third-party vendor, understand that ignorance of the law is not a defense, especially because the law says you are required to know the law. So there you go. All right. Incident response, again, you must have a documented incident response process, a protocol with which the vendor has been educated and trained to comply. And again, there must be consequences for not complying. You must include that in every part of this, because you probably already know that when there are no consequences for not doing what you're told, more people, then you get more higher into that 80% middle ground of people who will, well, this week because I was really busy with school and work and think about it, okay, is you have a really tough work schedule this week with overtime. You're taking several classes. You know, this one particular teacher, there are no late penalties for handing your work in. So just this week, you're going to hand that in late and take advantage of no penalties. Okay, and then just this week becomes just these 2 weeks. And then the next thing you know, a habit has been formed. This is why many of us here at the University of Central Florida and universities all over the country are very strict about deadlines. And this is why your bosses are strict about deadlines. And this is why the government is strict about deadlines. This is why things say within 10 days. Not vague is your friend. Okay. Again, that relationship between you and your vendors is very important. Now, when I say you, it might not mean you, the manager. You may have a designated individual on your staff who is the liaison between your organization and the third party vendor. Whoever it is that's in charge needs to be in charge. They need to understand exactly what's at stake, what is expected of them, what must be done. It needs to all be documented, because that's the only thing that counts when push comes to shove. And that pushing and shoving is happening in a courtroom. Okay, breach, recognition, notification, and initial response. We've gone over this before, and I know you should have gone over this in your other classes, specifically where you've discussed HIPAA, both the privacy and the security rule. But again, these specific details of the protocols with the federal government about what you need to do in case of a breach, that needs to be passed down in a very specific manner to your vendors. Oh, trust models for third-party interconnections. Remember, write down, educate, and enforce The minimum necessary least privilege rule. Now, in some of your other health information, health informatics classes, you should be familiar with the minimum necessary rule. This is a very specific part of HIPAA's privacy rule. In this venue, ISC2 and the organization that sponsors the HCISPP exam and responsibilities, they call it the least privilege rule. This is one of those cases, and I know we discussed it in the Domain 2 discussion forum, about different terms being used, and this is the facts. This is not our doing, this is the way things are, and this is part of the reason why we're working these reviews with you all, is to help you recognize when you know something already just by a different name. Okay, so if you already know the minimum necessary rule, then you already know the least privilege rule. Technical standards. These are the physical security controls, and remember, we've talked about them now during several of our domains, and remember, this connects specifically to HIPAA's security rule. So if you haven't yet, please absolutely connect with that HIPAA security, the security summary. I posted it in the course room, or the link to it in the course room. These rules must be followed. They call them controls. HIPAA's security rule calls it a safeguard. It doesn't matter. It's the same thing. Connection agreements, and this has to do with the interoperability, the technology connections between their computers and the organizational's computers. These must be done very specifically. And remember, you've already learned about encryption and the various types of encryption. This also must be specified with regard to the electronic transferring of any information, and who may do that, when they may do that, how they may do that, why they may do that, all of that. Information flow, mapping, and scope. And basically all this is a pretty little diagram that identifies the order of where information goes. So if we looked at let's look at a typical physician office visit by a patient, okay? Because I would think that most of you are very familiar with this. So the patient comes in, the first thing they do is go up to the reception desk and they sign in, okay? Then they go and wait. Now, the reception person will go ahead and identify that this person has an appointment, pull up their file, and put it next in line for the nurse who is working with that physician. Then the nurse will take the file, come and get the patient out of the waiting room, take the patient and the file into the exam room. Then the nurse or the medical assistant will then take the patient's vitals and enter that information into the record. And then the record is left there in a certain spot, whether it's on a laptop or in that little bin on the door, is left for the physician. Then the physician's going to come in and take the record and talk to the patient, examine the patient, enter information into the record, and then the record will go back to the next step, which will be usually coding and then billing and then back into the file system. That's a flow map. If you were to sketch that out, That would be a flow map. You take each one of these stations, if you will, or spots throughout the physician's office, and you put arrows between them. You have now made an information flow map with regard to the traveling of the patient's health record. So don't let this term intimidate you. You know exactly what it is. And that's what they're saying is what data is going where and for what purpose. Okay? How will the vendor access the data? Well, that all depends on what the vendor is doing for you, right? And then what business functions are using what data. So the patient's policy number is going to be used by somebody to confirm eligibility and verification. And then at some point, the coders are going to use this data so they can determine the ICD-10-CM, CPT, HCPCS Level 2 codes, and then the billers are going to take those codes along with information, demographic information, and other information from the patient's record to put onto a claim form to send to the third-party payer. Okay, that's another flow. You see, you can do this. And then, of course, we have to look at the sensitivity, and we have talked about this. Remember, we've talked about super confidential information and confidential information. We've talked about PHI. We've talked about demographic information. And then, of course, there are the business aspects of information, the strategic plans that belong to this physician's office, this clinic, or this hospital group. And then, of course, pricing strategies and models, because that's how a business stays successful. But all of that is sensitive information. And it is your job to protect data, whether it's the code that states the patient's HIV status, or whether it's the patient's address, or whether it's how much your clinic is going to charge for a flu shot. That's called proprietary information. So privacy requirements, by now you ought to know HIPAA's privacy rule inside out and upside down. And you need to make certain that the vendor and the vendor staff understand these requirements, take them seriously, know how to comply, and will be involved in complying. The security requirements, again, remember that our job to protect confidentiality is more than not opening our mouths and telling our patients' secrets to people. It has to do with locking the door. And the door now is inside of a computer. So it is very important that even if you see redundancy, it doesn't matter. Redundancy is better than, oh, I thought you had that, but you don't. Never assume. Make sure that what needs to be done is spelled out, because this is the most important part of communicating. Because if you don't spell it out and something bad happens, they're going to be the first ones to point to that and say, yeah, but you didn't say we had to do that. Seriously. All right, risk associated with third parties. One of the biggest risks of third parties is it's not your business, so you have limited authority and limited control. And you may only be dealing with one individual as their liaison with you, an account executive, or even if it's the owner. The fact is that you and your contract with this vendor must expand your authority from just being a customer to being able to see and get involved in everything and know what's going on. Okay, when you go into a business and it says staff only or authorized personnel only, your contract with this vendor has to make you an authorized personnel. Otherwise, you are flying blind, and that can get you in a tub of hot water. You also must identify the criteria to assess risk, because just like in the course room, in your other classes, you know, if they say, okay, read this chapter in the book, and then you're going to have a test on chapter 4, that is the criteria that is going to be assessed on the chapter, and that is reasonable. If you don't tell them what you are going to measure, how you're going to audit, what is risk, then they don't know how to reduce the risk or mitigate the risk or avoid the risk. And you learned all about all of those things, didn't you, back in Domain 4 and maybe some in Domain 5 as well. Okay, risk treatment identification. Okay, so we have done the vendor assessment, identified every item that has risk assigned to it, and identified the level of risk. And remember, we talked about this. Some things have high risk, some things are low risk. It's easier and more important for you to focus on fixing high risk items and then work your way down. And of course, remember we talked about the threat, the vulnerability, the impact, right? Okay. And so therefore, all of this must be shared with the vendor and given specific details as to how and what they need to do, and that they know you're going to come back and check their work. And then you have to go back and check their work. Corrective action plans, we've talked about this before in some of the earlier domains as well. And basically, it's logical, don't you think? Is you identify risk, you say, uh-oh, this window doesn't have a lock that locks solidly. It's too easy to pick or to force open, so we need to replace that lock. That's your risk assessment, okay? And if it's a ground floor window, then that's going to be high risk, right? That's logical. So then there has to be a corrective action plan, okay, right? We have to buy a new lock, a more secure lock, and then put the lock in, and then test the lock to make sure it's working. That's simple. That makes sense. So it's the same thing, only now we're talking about software and hardware and passwords and biometrics and even locks on the physical door or guards on the physical door. The fact is you have to be very straightforward with the vendor so that they can comply with what needs to be done in the proper time frame to very specific parameters. Because they will, when something bad happens, they will be the first ones to point and say, well, you didn't say it had to be within 10 minutes. You said as soon as possible. What the heck does that mean? Documentation of the documentation being improved to document. What's that line? The documents are documented in the documentation. Everything has to be documented. So not only is the risk assessment documented, not only is the corrective action plan documented, but then the mitigation, all the things that were fixed, repaired, have to be documented. And then the test or the review or the audit to ensure that all of those fixes actually were accomplished should be documented. Okay. Now, the HCISPP is a professional certification, which enables you, it's a credential that says you can be a subject matter expert to do security risk assessments, explain, do training, do audits, make recommendations for remediation and mitigation. And that is something you could do part-time in addition to another full-time job, or even have your own company. Sure, why not? You could do it. Okay. The primary entity, again, is responsible for establishing the parameters of breach notifications, which have already been established by the federal government. So therefore, you already know the details, but what you have to remember is that the vendor does not know that. The vendor may not have been in this class at some point. The vendor may not have gone to school for this. So therefore, the training must be done so everybody is trained and understands what to do in case of a breach and the time frame to do it in specifically. All right. Organizational information and dissemination of policies and standards. You know, I love the fact that back in the early 1990s, when desktop computers were first becoming very popular, and there were predictions that by the year 2000, we would be a paperless society. And to some extent we are, but to a lot of extent we're not. Now, of course, when we say documentation, that does not imply this has to be on paper. And as a matter of fact, what's better about using electronic submission of these documents is that computers and the software should automatically time and date the document entry, the details. So this makes it worth your while to create these forms in software so that everything can be housed, oh yeah, and backed up, all right? And everything can clearly be communicated. And remember, it not only shows entry, it also shows adjustment. And that tracking methodology is also very important. Maybe not on a day-to-day, but maybe when you are in a courtroom trying to prove that you did everything correctly and it was the vendor that did not follow the rules. So the risk assessment activities have to cover each and every aspect of what is going on. And that is going to be the human factor in addition to the computer factor, the hardware factor, the software factor, the environment factor, and all of it must be investigated. Remember, we don't assume, and certainly there is no reason for us to assume, because everything should be from day one, from moment one, be required to be documented, dated and stamped by and timed by the computer system. And then, of course, the chain of custody. This has to be done before the breach, hopefully to mitigate a breach, prevent a breach. But the fact is that this education has to come, you know, it's like taking a first aid class. Learning how to stop bleeding or what to do in case somebody breaks a finger is not going to do you any good after the event has already happened. You need to know about it before the accident, okay? And now it is your responsibility to pass this knowledge along to your vendors. And we want to make sure that everything is in order. And when we say in order, we mean cataloged properly, not necessarily chronological order, but the fact is usually it's in order of flow order. But everything has to be documented. That should be your middle name by now. Okay. So here we are at the end of Domain 6. Do you have questions? I'm sure you do. And I'm sure if you have a question, so do a lot of other people. So go ahead into the discussion forum for Domain 6 and let's talk it out.